What is the difference between a postnuptial agreement and a prenuptial agreement? I think one comes before and one comes after, or is it the other way around? A prenuptial agreement is intended to prepare you for your married life in the eventuality that 50% or more of marriages end in divorce. If indeed that is the case, how do you protect yourself going into that marriage? Or how do you protect both parties fairly and reasonable based upon what you know now? Because nobody has a crystal ball about whether somebody's going to become disabled, become a millionaire, win the lottery, have some giant inheritance from parts unknown or people unknown, or otherwise. Whereas a postnuptial agreement doesn't mean your marriage is over. It does not mean you've been granted a dissolution of marriage. It means that you are now in the position where your marriage has hit some rocky road. Not the ice cream variety, not tiramisu, not gelato. A very difficult, rough patch in your marriage where divorce has been discussed, contemplated. It may be likely. What then do you do? Well, many people do not want to get a divorce, whether it is the economy and tariff related, whether it is uncertainty of losing a two-party income, whether it is that you both want to remain in the marital home and nobody wants to be exiled from where they lived. Perhaps you stay together for the kids until a certain age. The reasons are voluminous, numerous, and your own. The fact remains that a postnuptial agreement is intended to become a sort of marital settlement agreement, the financial document that you both need if you're going to get a divorce. While that agreement might not cover everything conceivable, it will cover as much as is necessary or possible at that time based upon the facts that you know at that time. So there is a big difference. One is, with a prenuptial agreement, you've been married for approximately 0 days. With a postnuptial agreement, you may have been married for thousands of days and many, many years. You know more. You are no longer at arm's length. You are now together. You now have intimate knowledge of each other's finances. That is why there is a uniform premarital statute governing the discovery, i.e. the financials, bank account statements, pay stubs, real estate statements, loan statements, credit card statements, and everything in between, governing that sort of financial disclosure before you get married as a sort of protection, as a sort of failsafe, as a sort of transparency. Whereas that statute isn't a post-nuptial agreement statute, it is a pre-nuptial agreement statute, meaning that there is no statutory law necessarily that covers all of the bases and foundations for a post-nuptial agreement. In my opinion, though not every lawyer will agree, in my opinion, best practices are to look at the process of a divorce. I say that with a postnuptial agreement, you should still provide all of your finances just like you would have with a prenuptial agreement, even if you're considered to no longer be at arm's length in a transaction of this sort or a contractual episode of this sort. I say that you should still provide your disclosures to one another for full financial transparency to avoid this thing from being set aside or overturned. And in addition to that, you should cover as much ground as possible, resolving as much as you possibly can to avoid anything additional being needed if you're going to eventually get a divorce. Just because the law doesn't explicitly cover something does not mean that you cannot emulate the process necessary. If you didn't have this agreement and you had to have a marital settlement agreement, well, it would be created in a certain way. There would be rules, there would be legal applications and implications. So why not have a confluence of the two to the best of your ability? The number one reason that prenuptial agreements are overturned is because the parties never exchanged financial disclosures, or they are unconscionably unfair, disproportionate contracts of adhesion. If you're going to have a prenuptial agreement have such high standards, why not have a postnuptial agreement have high standards? Because that is essentially how you're resolving your entire marriage. Don't you want it to have a high standard? Don't you want it to be perfected? Don't you want it to be the best possible result of mutual negotiations so that there's no fight later? There's no motion to set aside? There's no doubt? There's no uncertainty? Nobody feels screwed over? Isn't it best that these two things, however they are different in time, however they may be different in legal precedent, if you will, what you have to do before one is created, they may be very different even conceptually, Because once you've lived a life together, you know more about what you need, what you want, what she needs, what he needs, what he wants, what she needs, and so on and so forth. And all of the property and debts you've accumulated, all of your spending habits and patterns, all of your behavioral mechanisms. There's a psychology behind this, miles upon miles and hundreds of miles, if not thousands of miles long. But if you treat them both as such a high standard, doesn't it stand to reason that the result of both of those types of agreements will be supreme and to everybody's satisfaction, to the extent that that will ever be possible based upon what you know now? Food for thought, ladies and gentlemen.